الفاضل جيمس ماكفرسون، وستكون مدتها 40 دقيقة. فنتمنى منكم الحضور والاستمتاع بمجريات هذه الجلسة. James, the floor is yours.
Welcome back, ladies and gentlemen. Hope you enjoyed your luncheon. So we're very happy to be doing a session on insurance and reinsurance, and we've assembled some luminaries from afar and from a little closer. The closer luminary being, of course, our sister, and that is Dr. Marian Caldas. She's Executive Director of the Egyptian Center for Arbitration and Settlement of Non-Banking Financial Disputes. Due to a minor mishap, she's not with us, but she will be on the screen. Can we put Dr. Marian on the screen? We'll get her up there shortly. Yes. So I think they're putting up slides. Marian, can you hear us? Can we get the audio for Dr. Marian? I believe Dr. Marian, according to Ustada Haura, is joining us by Zoom. What we can do, if there's a technical issue, we can begin with our two colleagues. And specifically, on my far left is Mr. Paul Wordley, who is also one of the sponsors of this event and speaking with his firm and on behalf of it, Wordley Law. Zoom. Thank you. So Dr. Marian will be joining us very shortly on the screen. And also joining Mr. Wordley is Kostas Frangiskidis, who is also with Wordley Law. Both of them have extensive experience working in the MENA region and internationally on insurance and reinsurance matters, including litigation, arbitration, mediation, and more. So they have extensive backgrounds. And so we're very fortunate to have both Paul and Mr. Kostas. And now we hear our sister.
Okay, did we start the session?
We are just starting now, and we were going to begin with you and your slide deck. Can you see, you may not be able to see us, but we can hear you. And I've introduced you, Dr. Marian. So if you would like to begin, they can press play for the slide deck and progress through it. The slide decks are for both Marian and Kostas and Paul are very compact affairs, but I think they're rich in content and utility. So, there she is. We see her on the screen. Hello. Nice to see you. So, Marian, would you like to begin your presentation? Can Ustada Dr. Marian hear us? She's Mojood, but don't know if she can hear us.
Yes.
Can you hear us, Dr.?
Do you hear me?
Yes. Can you hear us? We can hear you from Kahira. And the AI worked so well yesterday for the introduction.
I just can't hear you.
Can you, okay. Can you begin speaking? I'm not sure if you can see us.
I can see you, but...
Okay, I'm going to send you an email. Okay. Can you switch the presentation to Mr. Paul and Tim? Sure. Second slide. Okay, fine. Great. Once you need to change, let me know. Okay. We just put my finger. Yeah. Just say next slide. Next slide.
Okay.
Can you hear us, Marian?
So can we start with did you ask Paul or Costas, or you want me to start?
Well, if you could start, that would be great. Are you able to begin?
Okay.
Okay. Okay. We will begin with Dr. Marian live from Kahira. Can you press play for Dr. Marian's slides? The technical team. Can you press play for Dr. Marian? The green is perfect.
Yes.
Please begin.
Okay. So we're talking. Hi, how are you? It's very unfortunate that I'm not with you today, but I'm talking to you today from the Egyptian Stock Exchange. And we're talking today about insurance and the unique characteristics that differentiate insurance and reinsurance conflicts from other commercial disputes, and when they go to arbitration.
Next slide.
So you have the control over there. You can, Mariam, you have the control over there. You can switch the slides yourself.
Can you shift to the next slide? Oh. It's the green. You had the right presentation. The green one for Dr. Marian Haldes. Okay. Okay. Okay, carry on. Right. Okay, so we'll do. There you are. Second slide. Perfect. Continue, Dr. Marian.
Dr. Marian, if you can continue, can you hear us?
So insurance and reinsurance disputes, they differ from typical commercial disputes due to their highly technical nature, reliance on long-term contracts, and specialized industry practices. And the differences include the insurance and reinsurance agreements. There is technical complexities because the insurance and reinsurance agreements often involve specialized knowledge about underwriting, claims adjustment, actuarial analysis. That's why arbitral tribunals need to be able to understand the specificity of the insurance policies, the reinsurance treaties, and often the regulatory also landscape. Also, there is a special nature for these agreements. They are adhesive agreements. Insurance and reinsurance contracts are typically classified as contracts of adhesion due to the significant imbalance in bargaining power between the parties. And in most cases, insurers rely on core policies drafted unilaterally, leaving the insured with little, or I can say even no opportunity to negotiate terms. The choice is either take it or leave it. This structural imbalance often contributes to subsequent disputes over policy, interpretation, or obligations. Another also problem is the ambiguity in terms. And the policy language is often complex and ambiguous. And disputes arise when terms like trigger, exclusion clauses are interpreted differently by the parties. So this is less common maybe in commercial contracts, where terms tend to be more straightforward, but insurance and reinsurance, it's quite different. Also, reinsurance often involves layered risk sharing between multiple parties across jurisdictions. And disputes may involve complex retrocessions, structures, collateral arrangements, and multi-party interests that need careful adjudication.
Next slide.
One also of the concerns is that insurers and reinsurers operate with a highly regulated framework. This influences how disputes are managed, especially with international cross-border disputes, making arbitration more challenging in these cases. And to handle such disputes effectively, arbitration panels often requires experts, arbitrators who are experts and who are well versed in the insurance and reinsurance sectors, along with clear procedural frameworks to resolve these technical issues.
Next slide.
So shall I continue with the presentation, or will you be asking?
This slide that's up now is MENA and the Africa in numbers. Oh, can you go back one slide?
Sorry, I can't hear you.
We are on the MENA and Africa in numbers.
Okay, so now you want me to share also this PowerPoint. So now we talk like the impact of InsurTech and AI on arbitration, and let's talk about the number. With the rapid rise of the InsurTech across the MENA and African regions, where the market reached approximately $76.88 million in 2024, and is projected by TechSci Research to grow to $109.44 million by 2030. New complexities are emerging. In particular, the automated claims processing and AI-driven underwriting, introduce a range of challenges. They solve problems, but they introduce a range of challenges for dispute resolutions. For example, one primary concern may be the potential for AI-driven decisions to be biased or inaccurate. For example, if we say like an algorithm is incorrectly rejects a claim or underwrites a policy based on flawed data, or for example, or biased training sets, disputes could arise. The transparency and accountability of these algorithms will be critical in this case.
Next slide.
Also, another point is that as insurers and reinsurers rely on large data sets, claims against the algorithms, designers, insurers, or third-party vendors responsible for data collection and storage, and complexity in liability allocation between all stakeholders. Also, we have another concern, the disputes because of the IP. Disputes may emerge between AI platform developers and insurers if the ownership and permitted use of IP rights are not expressly clarified in the agreements.
Next slide.
Another also challenge in dispute resolution is that AI systems often function as black boxes, making it difficult really to trace how the AI reached its decision. So it's not clear how the AI reached its decision. This raises accountability issues. So if an AI model misclassifies risks, for example, or wrongly denies a claim, it becomes unclear whether liability rests with the insurer, the AI vendor, or the software developer. Another concern also is that policies and agreements may not have clear provisions on how decisions made by algorithms are treated, creating ambiguity when these decisions are disputed. So the challenges for dispute resolutions can be like summarized in algorithm bias or errors, the data privacy and security issues, the IP concerns, the transparency problems, and the contractual interpretation of algorithm-generated decisions. To adapt arbitration procedures to the following steps are essential. These are steps and tricks and tips. Arbitration panels will need to include experts in AI, machine learning, and data science to assess algorithm performance, data integrity, and the fairness of the decision-making process to mitigate those risks. Also, insurtech companies will likely be required to provide detailed records of how AI systems are trained, how decisions are made, and any modifications over time. This audit trail would help tribunals assess the fairness of the algorithm decisions.
Next slide.
Also, arbitration should expand beyond a mere technical review to also consider the ethical aspects of automated decision-making, such as fairness, discrimination, and bias, ensuring that the process aligns with societal expectations and legal framework. And this is also like very important. So we can conclude, also summarize this in expert witness in AI tech fields, audit trails and transparency, evaluation of ethical implications, and this is also very important to make sure that the AI and the insurtech will reach its goal. Okay, so we will also talk about the role of arbitral institutions. What can arbitral institutions or specialized arbitral institutions present? So the role of specialized arbitral institution is said to become more central in resolving complex reinsurance disputes, given that, especially those involving multi-layered risk concessions, structures, and cross-border placements. The key aspects of this evolution include like specialized arbitral institutions shall pay like considerable effort in appointing arbitrators, and this is the most important strength, appointing arbitrators who combine legal, actuarial, and technical reinsurance knowledge. This allows them to better interpret multi-layered retrocession structures and complexities, rendering accurate and expert-level awards, while saving fees associated with appointing external experts, except in certain circumstances. And we always talk about the cost of arbitration. Also, with the reinsurance placement over spanning multiple jurisdictions, arbitral institutions will increasingly focus on managing cross-border disputes. This involves coordinating between different national legal systems, ensuring the recognition and enforcement of arbitral awards, and adapting to varied regulatory also standards. Also, institutions may develop specific procedures, rules tailored to reinsurance disputes, which take into account the unique challenges of complex multi-party agreements dealing with AI-driven evidence, as well as the need for rapid resolution given the volatility of the insurance market. Another also important service is the specialized institution can offer a neutral forum for global reinsurance disputes, where consistent decision-making frameworks help ensure fairness, predictability, and efficiency across different jurisdictions.
Next slide.
This is particularly important in avoiding forum shopping, which can arise when the dispute spans multiple countries. Another also important service the specialized center can, like ICAS, for example, can also provide is the capacity building.
Next slide.
As insurance and reinsurance sector continues to evolve within increasingly complex regulatory framework, specialized arbitral institutions shall pay close attention also to training its calibers, including arbitrators, case managers, and administrative staff, because in such volatile environment, any error or delay in procedures carry loss of investments. According to White and Case 2025 survey, among the behaviors that most negatively impact arbitration efficiency is the lack of proactive case management by arbitrators. That's why at ICAS, we always invest in capacity building to ensure our services align with the dynamic and complex landscape. And this we see also with Aman Arbitration Center. They offer many arbitration trainings and also with other arbitral institutions.
Shukran. Doctor, can we suspend you for just a moment? And what we're going to do is shift to the other slide deck. And we're just going to hear from Mr. Paul and Mr. Costas, and we're going to come back to you when we're doing questions from the audience. So if you can hold right there, can we get the new slide deck for Mr. There we go. So over to Mr. Paul. Microphone.
Thank you very much.
I can't hear
the introduction. Thank you, everybody, and very much appreciate the invitation to come here and with the opportunity to present to you. If we could have the next slide, please. So I'm going to say a little bit about the appointment of arbitrators and the composition of the tribunal and its importance in terms of shaping or influencing the outcome of any dispute, whether in arbitration or through mediation as a result of the arbitration. The strategic considerations really start with what type of case it is, and it requires a detailed understanding by the legal team of the nature and complexity of an insurance or reinsurance case, and in particular whether it's a legal, factual, or technically orientated dispute.
Louder. Theater voice.
Can you hear me now?
Yeah.
Okay. So it'll require a detailed analysis by the legal team of the nature of the case and whether it's predominantly legal, factual, expert, or technical evidence-based. But perhaps more importantly is the nature and location of the subject matter and the type of tribunal that you as the appointing party want to have. And that means a lot of choice going into your party arbitrator nomination and the impact that appointment can have on the constitution of the balance of the tribunal. Now, most of the arbitration clauses in insurance reinsurance contracts are for three-party members of the tribunal, two-party appointed arbitrators and a chair. It's important to be able to appoint someone who can have a significant influence on who that chair could be. And ideally, if it's subject to New York law or English law or a foreign law, you want to have one as a minimum qualified lawyer from that jurisdiction on your tribunal, or they don't have to be located there. There's obviously a lot of English, New York and Canadian lawyers who are based out in this part of the world who will perform that role very, very well. So from my perspective, the constitution of the tribunal is the starting point for influencing the outcome of an arbitration in insurance and reinsurance, not just how the law is going to be interpreted, but how the law, facts, technical evidence and experts will all work together. And it's that complexity which I think makes the tribunal constitution process the important starting point for setting up an arbitration that will be successful.
Really loud.
Thank you, Paul. I'm going to be dealing with a core principle of arbitration, international arbitration. I describe it as core because it is, of course, important, and that is the independence and impartiality.
Can
you hear me?
Can you hear him? Or does he need to speak louder?
Should I speak louder? Can you hear me?
They want you to do this.
Is it loud enough now?
This is better.
That's better. Okay. Hello?
There you go.
There you go. Okay. I won't, I'll continue. I was going to start singing, but just to make sure I was loud enough. So I'm looking at the core principle of international arbitration, which is independence and impartiality of the arbitrators. I'm going to be looking at this from the perspective of English law, and I'll be doing that throughout my sections with the agreement of the mediator, James. So we're not trying to make it UK-centric, but because some important principles have been considered before the English courts and also have been amended effectively to make English law more pro-arbitration by the Arbitration Act 25. Now here the issue is that had to be grappled with, and it went before the Supreme Court in the case of Halliburton and Chubb, was what was, is there, and what is the duty on arbitrators in English-seated arbitrations to disclose matters that could give doubts as to their impartiality. Now here, the test, as I'm sure you are aware, is of apparent bias. And in this case, there were, it was a Bermuda, what's called a Bermuda form program with a number of insurance layers. And one of the insurance contracts, which this matter related to, had New York governing law of the main contract, and the legal place of the arbitration was London. In that arbitration, the parties could not agree to the chairman. So the chairman was appointed by the court. After he had been appointed, the same individual was appointed by Chubb, a common party, to the first arbitration as their party appointed arbitrator. The chairman did not disclose this in the first arbitration to any of the parties. Halliburton found out about it and challenged the appointment of the arbitrator on the basis of his lack of impartiality and that he was guilty of apparent bias, or he would fall within the test of apparent bias. Effectively, what the Supreme Court, and the reason this is important for international arbitration, is that when the Supreme Court looked at this, there were interventions by the ICC, the LCIA, and the Chartered Institute of Arbitrators. What they decided was the test, which is a well-established test in international arbitration and in relation to English law, is an objective test. It's not a subjective test. It's not what the arbitrator knew. It's what objectively the fair-minded and informed observer would have concluded, and whether there was a real possibility that the tribunal was biased. So the important point here is it's an objective test. It's what the fair-minded and informed observer would consider. And that is a duty now on arbitrators They have to disclose they have any reasonable doubts as to independence or impartiality.
Next. Can I ask you a question?
Hello? Could we go to the slide headed liability insurance tower, please?
Next slide.
It's about 6 slides further on.
Next slide. Oh, wait. That's
Next slide. Keep going. That's it. Thank
Stop.
you.
Thank you.
I thought rather than tell you what English law is, I thought I'd talk you about some practical experiences of where complexity comes into the work that we do. And Marianne, I think in her slides, presented very well on some of the technical forensic expert issues that arise in the context of insurance and reinsurance cases. And this is based on an example of a claim we were involved in a few years ago. And it's a liability insurance tower of $600 million, with $100 million placed mainly some in the local market, but mainly on a facultative basis into the London market. And then there's a layer of 200 million, which is placed internationally, and then another layer of 300 million on top. And if we could have the next slide, please. This actually breaks down into a number of individual contracts. So in the blue column at the bottom, that is a mixture of local market and London market. Now, depending on the country where the risk is domiciled, the local market contribution or participation will be governed by regulatory requirements. It could be, let's say, 10 million, or it could be more. But normally that, what is often referred to as a working layer, say $100 million of liability cover, will all be on the same contract. It'll be on what's called a subscription basis, usually, so that everyone is participating on the same contract wording. And when you then get into the red layers, you're into individual contracts with individual insurers, and the green layers, you're similarly on individual contracts. Now, I've put through here the different insurers. So the blue layer area is subscription market, various insurers, and local. The next 4 are on their own contract forms, but they often are similar, but not identical. And I've said that these are with US or Bermuda insurers and a German insurer. Then the top layers, I've made US, Swiss, and US and Swiss insurers. Next slide, please.
Next slide.
No, this is fine. This is fine, thank you. Sorry, that's it, thank you. Now, if you look at the applicable law, you'll see that the bottom layer is the one that will be local law, or possibly a mixture of local law for, say, 10 million, and then English law. But then the rest are going to differentiate between English law or New York law. Now, New York law is favored by a lot of international carriers, particularly Bermuda-based, because it's the most favorable law in the US for insurers. It's the exact opposite of Californian or Texas law. English law is usually chosen for some of these carriers. It comes out of what's called a Bermuda form, which is a basis of cover created in the 90s when there was a complete collapse in the international insurance market. And the Bermuda carriers were set up by the multinationals, oil and gas, mining, banks, etc. And then those companies, which were known as ACE and XL, were sold off. ACE is now Chubb, XL is now AXA. But when you get into these higher layers, they are standalone contracts, not necessarily identical, although the brokers try to make them as close as possible. And the choice of law has a different impact on what the policy means and how it responds, particularly on liabilities and compromise payments, where New York law allows a compromise to be entered into and binding on the insurers, if it's reasonable to do so, whereas English law requires a finding of liability on the underlying claim by court award, court or arbitration award. Next slide, please. And then this last slide will show you how, if you get into arbitration and all these certainly the red and the green contracts will have arbitration where you get into more complexity because they won't always have the same seat. It so happens on Bermuda form that London seat was chosen and has survived, although at one stage it did move to Bermuda. It's now moved back to London for the last 15, 20 years. But increasingly, we're seeing the higher layers of cover on international programs choosing places other than London. For example, Geneva is, we've seen, also Stockholm we've seen. So you can see now you've got a mixture of different curial law, depending on where the arbitration is, different interpretation of procedures, depending on where the arbitration seat is, and then you've got different law impacting the potential outcome of a liability claim. Now, just pausing here, if you're unfortunate enough to have 8 arbitrations all arising out of one incident, when you're actually talking about choice of arbitrator, which is what I spoke at the beginning of this, you actually can't just appoint the same tribunal because obviously it's got to be consensual, and different carriers, different insurers will choose different party arbitrators. So then the influence of your party arbitrator becomes important because you could try to put some consistency into how these disputes are dealt with up the tower. So if you want your party arbitrator appointed on 7 or 8 arbitrations, can that person influence who the umpire is or the chair is so that you've got consistency going throughout the tower? Just on a practical point of view, if you've got 7 or 8 arbitrations on the go at the same time, it's actually quite difficult to have the same arbitrator appointed as your party arbitrator. So then you're starting to think about, can I appoint like-minded arbitrators? I might have 2 or I might have 3, depending on their availability. But these are considerations that you really only get into when you understand the facts, the law, the expert, the technical drivers of an outcome. And then this is an added complexity which has to be taken into consideration.
Very good. I wanted to ask a question of Dr. Marianne, and specifically because of her experience in this field, I wanted to know what unique characteristics would you say differentiate insurance and reinsurance conflicts from other commercial disputes that are brought to arbitration? Who's that? Is Dr. Marianne still with us? We will pause with Dr. Marianne until she gets her back, but I don't think we need any slides anymore, so we can put up the general background. But I will shift instead to a not disinterested question for Paul and Kostas. I'll go straight for the jugular. Where does mediation fit in with insurance and reinsurance in terms of efficacy, utility, and in the Arab MENA context as is rooted in the region?
James, I'll go first. As
I can hear only you.
As I'm a keen supporter of mediation in insurance and reinsurance.
Hang on. We really want to make sure they hear you. So can you put your fingers around the mic a bit?
I'll go first, as I'm a keen supporter of mediation in insurance and reinsurance, particularly in the international context. So firstly, the insurance and reinsurance industry is very good at investigating claims, ascertaining the facts, the issues, the expert evidence, and the technical case to support a claim or otherwise. So that means that at a point in time when all the parties have done their own investigation, they should be in possession of enough of the facts and understanding of the issues to be able to sit down and work out what is the least point of pain for them in terms of settling a claim. Now, obviously, at this stage, everyone's focusing on litigation risk if they continue to arbitration or local court if that's the jurisdiction. But mediation is extremely useful because the parties are regularly in a significant enough position to sit down and discuss in an open, obviously without prejudice basis, how a matter might be resolved. And the mediator obviously plays a key role in ensuring that the parties can move towards each other, but not necessarily having to arrive at a determination of an issue. It really is the point of least pain or the most optimum outcome for the parties based on what they want to do.
Hear the session itself.
I would add that the insurance and reinsurance market. The insurance and reinsurance market is intermediated, as in there's brokers, and brokers are very good at facilitating negotiation, but sometimes that falls short of what can be achieved in a mediation, because sometimes the broker should be there as a party to the extent that if something has gone wrong in the insurance and reinsurance placement, the broker has some accountability and therefore should be at the mediation in its own right.
Now, I think we heard Dr. Marianne a moment ago. Is she able to rejoin? Dr. Marianne? Oh, hello.
Yes, I am here.
So you can hear us?
Yes, I can.
Excellent.
Hear you.
So I have a question for you, which is, because of your experience in the field, I wanted to know, as a leading arbitral center focused on non-banking disputes, it said my battery is running low, it's not. The question was, what unique characteristics differentiate insurance and reinsurance conflicts from other commercial disputes that are arbitrated in the MENA region?
So, I think, you didn't hear me from the first one. I answered this question. Did we present this right?
You did, but I was thinking, we thought you might add some context, because obviously a lot of the people here have been in the arbitrations, and from a practical standpoint, are there regional differences as well?
Yeah, I would like also to talk about one main issue, very important, is what the consideration should insurance stakeholders keep in mind when entering into a contract, and how they should approach disputes, because as you said, James, they are different from commercial disputes. So I wonder if I can talk about how to avoid those potential disputes and how to solve the disputes, or how to resolve the disputes when they arise.
Please do.
Because they have technical. Okay. So when entering into insurance contracts, stakeholders should consider several key aspects to first avoid the potential disputes, as we said, and second, to resolve also the disputes if it already occurred. So to avoid potential disputes, we need first clarity in contract language. Also, we said that one of the main problems in insurance policies is the ambiguity of the language. So ambiguity is one of the primary causes of disputes in insurance contracts. And that's why all terms, especially those related to exclusions, triggers, and claims, procedures, should be clearly defined to minimize various interpretations, so that we don't have a number of interpretations. Also, the risk mitigation measures should be taken. So provisions for risk allocation, including, for example, how claims will be handled, what constitutes a claim event, and how reinsurance claims are triggered, should be clear. These provisions can help resolve disputes before they escalate. Another also important aspect to take into consideration to avoid disputes is to invest in your legal team. It is really crucial to ensure that your legal team understands the underlying risks in policies, as well as keeping updated with the legislative reforms and the decrees regulating insurance and reinsurance sector that can impose certain criteria and standards in assessment of claims where no deviation is allowed. Also, the midnight clause that we always talk about in all the arbitration events. The dispute clause should clearly define the dispute process in the contract, whether through arbitration, mediation, or any other method. Multi-tier dispute resolution clause is favorable in these complex disputes, and it can save parties a considerable time and money So we know, James, you are the star of mediation, but we always, even in the center, advise people or advise the insurers always to include mediation before arbitration. Also, we should include the seat of arbitration, the language, the chosen institution, the applicable rules. The choice of law and jurisdiction is also very important given the global nature of insurance and reinsurance. Stakeholders should carefully choose which jurisdiction law or laws should apply to the contract. So when actually disputes arise, what to take into consideration? Number one is very important to intervene at an early stage. Proactive engagement with a dispute resolution mechanism like, for example, mediation or expert determination can often help parties resolve issues without resorting to full-scale arbitration. Multi-tiered also dispute resolution clause can significantly save time and money for the parties. And we strongly recommend that you always start with mediation. Transparency and good faith also is very important. So parties should maintain transparency and act in good faith when dealing with disputes. And this is a key issue in insurance disputes. Open communication, sharing information, and attempting to understand the other party perspective can sometimes prevent escalation into full dispute. We always say that the choice of arbitrator in an arbitration dispute, if you choose the right arbitrator, you have done half of your homework. So arbitrator selection is very important, and we have to focus here on the expertise and conflict of interest. Given the complexity of insurance disputes, stakeholders should give priority to appointing arbitrators with specific expertise in the insurance and reinsurance field. Knowledge of the arbitration procedures and the laws is not enough, but priority should be given to expertise in insurance due to its complex nature. This ensures that the arbitrator understands the specificity of the industry and the standards and the regulations and practices.
I'm not sure if you can see. Can you see us?
No.
No. Oh, right. Well, what we're going to do is open for you and for Paul and for Costas the floor for questions. So can we see a show of hands
I have finished already.
of anyone? Shukran jazilan, Ustadha. So have we got questions from our colleagues on the floor? We have two hands here. But why is it two Brits? Where are the Omanis? So we'll begin with Sean and then Michael. And then, inshallah, the rose and gold of Oman will come to the surface.
In terms of the region, are you seeing mediation written into the contracts themselves, or is it ad hoc mediation?
Do you want that?
Good question. We tend to see disputes on contracts that are already in existence. So the arbitration agreement in the reinsurance or insurance contract was written some years ago. If we were reviewing a contract at the get-go, we would put in an escalation clause which includes mediation before proceedings are commenced. So we don't see it, but people are open to it as a way of resolving a dispute to avoid the costs and confrontation of an arbitration or litigation.
And even the ones that have the escalation clauses, they are typically not going through the institutions. So they're both in the clause and arguably ad hoc. Which for anyone here who's doing this sort of thing, I think there is value add to going to centers like the Oman Arbitration Center, because they have a skilled staff, they're very focused, they have the facilities, they know the players, they know the culture, and they're able to get everybody assembled on track and collect the information and so forth, whether it's for a mediation or an arbitration. I think their secretariat can add value. Did you want to say anything, Costas?
Yes. I think as far as the arbitration agreement, the arbitration clause is concerned, as Paul said, that is often described as the midnight clause. So everything else is agreed, and then at midnight they think, oh, we need a dispute resolution clause. They don't think about it. If I had time, I'd talk about the law of deceit and the law of the agreement and the substantive law, because often the choice of law of the agreement, it's a contract, isn't even stipulated, and that creates lots of problems. So before we even get to mediation, we have other problems. And I think the other issue is that a lot of the institutional rules have their own mediation procedures, but again, usually by the agreement of the parties, and parties are generally very far apart by the time they get to arbitration.
So, Maria, did you want to say something before we ask Michael? I'm not sure you may have heard the question. Well, let's pivot to Michael, if he's got the microphone. It's not on. Your microphone's not on for some reason.
There, is that better?
Yes, and really into the mic.
Michael Patrick Joyce, barrister, arbitrator, and mediator. I'm very tempted to pick up on Sean's question and what Paul was saying and ask about mediation as a tool in support of enforcement. But in fact, I'm going to go back to what Costas was saying about the objective test with regard to conflict of interest and the Halliburton and Chubb, and the need for a fair-minded and informed observer. One of the issues in Halliburton and Chubb, and indeed the interveners through the London Maritime Arbitration Association, was to draw attention to the specificity in certain relatively narrow and clearly focused areas of arbitration. Where you may have repeat arbitrators, you may have a very small pool of arbitrators. And my question, therefore, is how knowledgeable, how market savvy does the objective observer need to be? Because someone taken from the street may see a conflict of interest when the market players in a very specific niche area may see none. How is that to be reconciled?
It's a very good question, because as Michael rightly points out, one of the exceptions is if there is some sort of sector practice, i.e. I mentioned on the slides the London Maritime Arbitration Association that deals with maritime disputes. There, it is even prescribed in their rules that because there is a small pool of arbitrators, there is no duty to disclose overlapping arbitrator appointments where there is a common party. So it's a bit of a catch-22 because the chap, the layman, the fair-minded, informed observer, if he's not in arbitration, he might be in the maritime business, but if he's not in arbitration, he wouldn't know that. So of course they would then spend money and waste money by objecting if they found out about an arbitrator who was involved in other arbitrations with the same subject matter and common party. There would be an issue. It would just increase costs because then the challenge wouldn't succeed.
Paul?
I'd just like to add to that objective is very important because the law of the sea will determine whose objective test you're applying, and the objective test in Oman or Dubai or Kuwait or Saudi could be very different from the objective test in New York, Geneva or London.
Now, do we have, oh, yes, right next door, Badlu.
Hello. Okay, thank you. My question actually is direct to both the gentlemen regarding Halliburton case. If the arbitrator who was challenged in Halliburton case has not been the Mr. Rickson, would that change the position of the English courts in their decisions? In other words, suppose that myself was instead of Mr. Rickson, would the English courts have taken the same decision in rejecting the disqualification or not?
We couldn't really hear that. Michael, did you hear the question? It's because the speakers are, we don't have monitors. So if we were doing a concert, we would have floor monitors so we could hear. So yes, that's what I was also doing. So our moderator, Michael,
Yeah.
you got a really blessed.
It's an interesting question because it's really a sort of parallel universe question. If one takes the arbitrator in Halliburton and Chubb and replaces the arbitrator who was under challenge by, for example, a questioner, would the English court have adopted the same analysis? I think it's maybe quite a difficult question to answer because you're posing a counterfactual and you would need to look at more detail in that counterfactual.
I'll find the sound.
Right. So we put the questioner in exactly the same circumstance as the challenged arbitrator. Would you be subject to the same challenge as the arbitrator?
Go ahead.
Sorry, could you just just explain the question's background and why his situation is different to the individual in the Halliburton? Because we didn't quite get that.
This was why I was putting it on the basis of a counterfactual. Sorry, is that better? Okay. This was why I was putting the question on the basis of a counterfactual, because I think the concern is as to whether there was some sort of generalized basis of challenge which went beyond the specific circumstances of that particular arbitrator.
No.
And therefore, whether someone such as a questioner could perhaps unexpectedly and adventitiously find themselves in the same position, whereas they had no inkling or no indication that that was going to be forthcoming, which is why I put it as a counterfactual. But I think the very posing of the counterfactual,
I think I understand
indicates the question. Indicates the answer.
I think I can answer it by reference to the case, because of course, when the chairman had been appointed by the court, the chairman, the arbitrator there, was then allowed himself and agreed to be appointed on another case. He didn't. The whole point was he didn't disclose that he had been appointed on overlapping arbitrations. The law then clarified that he should have disclosed, but the challenge didn't succeed for the main reason that that arbitrator at that time was not aware, the law was too uncertain. So if you had been that arbitrator at that time before Halliburton and Chubb, you wouldn't have been. And again, I should mention all of these facts are taken into account when you consider whether or not somebody satisfies the test of apparent bias, i.e. is not impartial. I don't know if that's answered your question, but the counterfactual was considered in Halliburton.
You can speak directly to these gentlemen now, because we're going to leave the stage, and we thank Dr. Marian, we thank Paul, we thank Costas, and right now we have the most exciting event of the week, which is the mock arbitration. It's sort of like mud wrestling, but much more violent. Here it comes, ladies and gentlemen, the mock arbitration.
Thank you to our esteemed speakers. أعزائنا الحضور، نصل الآن إلى آخر جلسات اليوم، وهي عبارة عن محكمة صورية. تدار الجلسة من قبل كل من الفاضلة سارة مالك، الدكتور رياض البلوشي، الدكتور طلال جابر، الفاضلة كلوديا حاج، والفاضل مايكل باتشيت، والفاضل درو هولنر. إذن سنبدأ بتجهيز المسرح لهذه الجلسة الصورية. بعدها من الممكن للمتحدثين الكرام التوجه إلى المسرح. شكرا لكم.
No, just put. Ladies and gentlemen, I'm going to invite you to come forward. Please do, because this is an interactive session and I want you involved. So all of you who are at the back, please make your way to the front of the room. Thank you. We're just setting up and then we'll get started. Claudia, Arabic.
بنتمنى للي جالسين خلف يقربوا لأنه رح تشوفوا محاكمة صورية وكتير فيها تفاعل مع الحاضرين. بقى بنتمنى القاعدين ورا يقربوا لقدام لو سمحتوا.
Please move forward. Thank you. Thank you very much. Sorry. Is that everybody moved? Please don't be shy. Come to the front because we'll be asking you to be involved.
ايوه مين من المايك مين من
Are we good, guys? I'll get started. Let the guy come. Ladies and gentlemen, it's my absolute pleasure to welcome you to the first edition of the Behind the Scenes in Muscat. If I can have your attention, please, I'm going to introduce firstly our panelists and tell you what's going to happen today. Can I please have your attention? I'm quite strict. Thank you. Okay. So today's proceedings are mock arbitral proceedings, and what we do, and we've ran this event successfully in Dubai, in Lebanon, in Saudi, and it's a very popular event, backed by demand. We show you what happens behind the scenes in a tribunal. We have counsel, we have a 3-member tribunal, we have a scenario. There should be a scenario on your desks, and I think we have a QR code that we can put up as well if anybody wants to follow it. There's a scenario, there's a claimant, there's respondent, there's issues that we'll deal with. And how we run these proceedings is counsel will give their submissions, tribunal will ask questions, and then I will literally freeze them. And I'll turn to the audience and I'll ask you what you think is going on and who you think is right or wrong, or what you think about what is happening. And then the tribunal will give their ruling on every issue. I need to tell you at the outset a disclaimer. Our counsel and our arbitrators are tasked to play a role for your benefit. So we exaggerate, we role play, we make some drama. They act out of character. Every one of these people I can vouch for are completely professional if you ever instruct them as counsel or arbitrators. And today's role is role playing. So don't be alarmed if you see some things that may not happen in tribunal, but actually what does happen is what we're showing is just an exaggerated version of what we do see. So, ladies and gentlemen, without further ado, let me firstly introduce our panel very quickly. As our tribunal, our presiding chair, we have Professor Dr. Talal H. Jabbar. For the purposes of today's proceedings, his name is Dr. GCC. He's a holder of BA in Law, an LLM in Business Contracts, Diploma in Anglo-American Law, PhD in International Business Law. He's written a book, Introduction to Business Law, in 3 editions, taught at the top-ranking universities, covers many topics, and his book, International Sales of Goods, is one of the first reference in Lebanese law. Very well-known figure internationally, and also on the organizing committee, as am I, of this inaugural event. Okay. We also have Ms. Claudia Haj, and for the purposes of today, she is the appointed arbitrator for the respondent, and her name is Cleopatra Al-Mars. So Cleopatra Al-Mars, or Claudia, from Qatar, originally Lebanese, legal counsel, arbitrator and civil law expert, over 25 years of experience across multiple jurisdictions, particularly in the Middle East, regularly appointed by institutions such as ICC, LCI, DIAC, and QICC, specializes in construction, real estate, corporate banking, and M&A, and her practice includes litigation, ADR, regulatory and arbitration-related proceedings with a focus on the Middle East and France. And last but not least, from the jurisdiction, we have Dr. Riyad Al-Balushi, and for the purposes of today's proceedings, his name is Dr. Rashid Al-Farsi. He is the CEO of Decree, an Omani legal tech startup to empower society with legal knowledge by providing access to information using state-of-the-art tech. Prior to founding Decree, he worked as a legal advisor for government, and he's worked in roles of Director of Treaties in the Ministry of Justice and Legal Affairs. He has extensive experience in public international law and represented the government in negotiation treaties in investment, tax, civil aviation, immigration, security, and he's worked on several internet governance projects, holds an LLB, LLM, and PhD. And now I turn to our counsel, who have very kindly flown in from London. On the left, Mr. Michael Patrick Joyce, who's a barrister and arbitrator at and mediator at 3 Hare Court, Temple. For the purposes of today's proceedings, he is the respondent's representative, and his name is Mr. BBC. Michael is a highly experienced barrister, arbitrator, and mediator, strong focus on domestic and international dispute resolution, and he's a founder of Gulf Mediation. He's got long-standing ties with Dubai, UAE, and the wider GCC, MENA regions. Very hands-on approach. I can vouch for that. I've worked with him. Excels in complex litigation and arbitration and leads multinational teams. And he served on the UK Bar Council's International Committee. And last, by no means least, we have the claimant counsel, Mr. Drew Holliner, and for the purposes of today, his name is Mr. Pluto. He specializes in commercial dispute resolution. He's admitted to practice in Russia, UK, and United States, as well as the DIFC. And he focuses on international commercial arbitration, litigation, Russian and CIS law, public international law, and he's conducted arbitrations under DAC, CIAC, HKIC, ICC. A very well-known and stellar panel who are going to role play for you today. Hopefully on your tables, you'll have a copy of the bundle and you'll have a copy of the scenario. And I'm going to just very quickly run you through the scenario and then hand over to our tribunal. So in a nutshell, the scenario is like this. In June 2024, Oman Space Conference LLC enter into an agreement with Bright Vision Media LLC. And what the agreement is exclusive digital broadcasting services for the annual Oman Space Conference. The fee is 6 million Omani per year for a 3-year term. And the service is a live streaming, on-site digital coverage, post-event highlights, and social media integration. The arbitration dispute clause in the contract says any dispute arising out of or in connection, including any question regarding existence, validity, or termination, shall be referred by and administered by the Oman Commercial Arbitration Center in accordance with the rules of the Oman Commercial Arbitration Center 2020, which are deemed to be incorporated. Number of arbitrators 3, seat or legal place shall be Muscat, the Sultan of Oman. Language of the proceedings is Arabic. So what's happened in this dispute? I'll run you through it quickly. In July 2024, the respondent delivers a live stream, but there's tech failures and there's interruptions. So several keynote addresses are not broadcast from space and the sponsors complain. In August 24, the claimant doesn't pay part of the first payment, which amounts to 2 million Omani Rial. Because they say there's been defective performance, we're not paying. September 2024, respondent wants the full payment, and they say the disruptions were nothing to do with us, they were outside our control. And in December 2024, the claimant says breach and termination. So today, our tribunal are going to deal with a number of issues. They're going to look at the request for arbitration and the language that's used. They're going to look at the response and counterclaim, and if a party is out of time. There's going to be a challenge to our tribunal, to the presiding arbitrator. We're going to look at interim measures, and we're going to look at the admissibility of evidence. I'm going to hand over now to our learned chair to open proceedings. And as I say, when I freeze them, they go quiet and we talk. And over to you, Mr. Chair. Thank you.
Good evening, councils. Good evening, esteemed colleagues. I would like to welcome you today to our mock arbitration proceeding, case number 001/25, between the claimant, Oman Space Conference, LLC, and the respondent, Bright Vision Media, LLC. Now, to begin with, and for us to respect the issue of confidentiality of the proceedings, and since we have lots of attendees who are not part of these proceedings, I would kindly ask from the esteemed councils to give their formal approval on the attendance of the esteemed audience here. Are you okay with it? Thank you.
No objection on behalf of the respondent.
Thank you very much. So now we have a confirmation about the approval on the attendees. Welcome all to these mock arbitration proceedings. So to begin with, I would like to identify the parties that were already identified in my beginning, or at the beginning. So Mr. BCC, Learned Counsel, you represent the
Mr. Chair, indeed, Dr. Chair.
Yeah.
Mr. BBC, represent the respondent. I'm not too sure what the acronym BBC stands for. You can treat it as brightest and best counsel, but modesty forbids me to go further.
Or the news agency, no problem. On the claimant's side, we have Mr. Pluto.
Yes. That's right.
Go ahead.
Yes, I'm Mr. Pluto, acting on behalf of Oman Space Conference LLC, as the name befits. not quite from outer space, but having ambitions.
Yeah. Well, I believe both councils have submitted their respective IDs with the request for arbitration and the answer to the request for arbitration. Is it true? Is it on file? Is it on record?
Yes.
Okay, so everything is confirmed. And the power of attorney, is it also on record? You present it or not yet? Can I see it, please? Yes.
You can return it, please.
Rejected. I'm joking. Can I see your
And
power of
my
attorney?
power of attorney, sir.
Thank you. Thank you. Okay, thank you very much. So we move on to the proceedings. Actually, the language of the proceedings is in Arabic. However, for practicality, because some of the attendees don't speak Arabic, we will do it in English language. However, translation will follow the transcript according to OAC rules.
Well, Dr. Chair, we do have an issue in relation to language.
Excuse me, I didn't give you the right to speak right now, Mr. Counsel, so please, can you wait a little bit? Thank you very much.
But we still have an issue, Mr. Chair.
Yeah. Order and discipline is a must with this tribunal. Thank you. So, we will be giving, before we talk about the issues to be determined, as mentioned by Sarah, we will be giving at a later stage the time for the parties to give their statements, and we will be giving each party around 10 minutes maximum. It can be less. So we start with the claimant and then we go to the respondent, also another 10 minutes, and the proceedings or these such statements will be followed by some questions to be asked by my colleagues, members of the tribunal.
Mr. Chair, if councils could limit the pleadings so we can get to the coffee break on time, that would be much appreciated.
Please talk to me and I will talk to them. Thank you. So we begin with the claimant's representative. We are all ears. The floor is yours. Thank you very much.
Thank you. Mr. President, members of the tribunal, before, of course, we get into our submissions, but there are some procedural matters that need to be dealt with. As you mentioned, the language of the proceedings is an important issue. And we have noted the respondent's objection, recent objection, to these proceedings going forward in English, because the arbitration agreement specifies Arabic as the language of the proceedings. So, first of all, we wish to acknowledge that our request of arbitration of 15th March was filed in English, and we accept that the arbitration clause refers to and specifies Arabic as the language of the proceedings. Nevertheless, we submit...
We are bound by the clause. However, for practical issues, we will allow pleadings to be done in English with direct translation to Arabic.
Well, if I may, Mr. President, I, with all due respect, would like to ask why the parties have decided to appoint non-Arab speakers in an Arabic arbitration.
This is precisely what I wish to get onto, and it will be referring to two provisions of the rules. The first dealing with our initial filing in English, and the second is how we go forward in these proceedings. So as to the initial filing...
Madam Member of the panel, I can answer your question.
Please, learn counsel. Let him finish and then you will continue, please.
Yes, I will.
Just answering the question.
I will complete my thought and then you feel free to
intervene. I will give you the floor.
So the applicable provision here is Article 3.2 of the OAC rules, which expressly provides that
you may take notes and then answer him.
All communications to the registrar shall be in either Arabic or in English, notwithstanding the language of the arbitration. Now, under Article 4.1 of the OAC rules, the request for arbitration is clearly a communication to the registrar. So the initial filing in English was fully compliant with the arbitration agreement, which specified OAC arbitration and therefore OAC arbitration rules. So even though the proceedings are in Arabic, by incorporating the OAC rules, they accept that the request may be filed in English. Now, we accept that if the tribunal so directs, these can be translated into Arabic going forward. But we submit that we're under no obligation to doing so for the following reason. That considers going forward, Article 43 of the OAC rules specifically refers to a situation where a party fails to object within 14 days of their knowledge of non-compliance with the rules. Now, we filed our request for arbitration. The response was filed more than 14 days later, 20 days later, by the respondent. Not only was no objection raised as to the submission in Arabic at that time, in fact, they filed their own submission in English. So this is clearly a situation where they have waived their right to Arabic proceedings.
Learned Counsel, allow me to interrupt you, sorry, but this issue was solved between us as a tribunal, and we unanimously decided to adopt the strategy that was given to you at the beginning, is that we approve doing it in English. However, direct translation should be made to Arabic according to OAC rules. So I think this issue is solved. Do you have any comments on this?
Well, I will not seek to put words in the mouth of Mr. BBC, and if he agrees and he has no objection to that, we certainly are with the tribunal with this 100%. The only point that we would raise is that under Article 24 of the AOAC rules, that the proceedings should be without unnecessary delay and expense, and we submit, we're all here, both counsels speak English, the entire tribunal speak English. It's not necessary to have this duplication, everything in two languages. I would submit if they haven't waived it,
we need to respect the clause. We need to respect the clause. It says Arabic. And this is consensual. It was signed by both parties upon signing the agreement. So we cannot change this without the unanimous approval of the parties.
Well, right? This is precisely what we're referring to as Article 23, is that the respondent has waived their right to have the proceedings in Arabic by failing to object in time. And even if the tribunal is not with us on that, we suggest that it is completely unrealistic to suggest that we should have parallel languages in this arbitration when the respondent...
Thank you, sir. Thank you, sir. Learned Counsel?
Members of the tribunal, in the response to my learned friend's case, I am not only the voice of Bright Vision Media, I am the voice of reason. Quite frankly, my learned friend, Mr. Pluto, is in this respect on another planet. But before I get to the substantive response to my learned friend's argument, let me deal first...
Referring to his name or to his place, Pluto?
Well,
on another planet.
Mr. Pluto, I mean no disrespect when I say that he's on another planet. I'm simply talking about his argument in this regard.
Maybe you are talking about Oman Space Conference and space, so Pluto is a planet.
No, it was a much more limited point than that, Dr. Arbitrator. But let me immediately respond to the point made by your colleague as to why should we choose to have Arabic arbitrators. The point is clear because the matter is seated in Oman, and speaking personally, having come from London at this time of the year, where and with which panel of arbitrators would one rather be? In London, rainy, overcast, cold, or here? It is obvious, and that, of course, is the answer. But let me respond to my learned friend's arguments. The claimant's position simply attempts to circumvent the clear agreement between the parties. And what is most important in arbitration? Party autonomy. Clause 10 states quite clearly, unequivocally, the language to be used in the arbitral proceedings shall be Arabic. No ifs, no buts, no qualifications. Now, whilst Article 3.2 may permit initial communications to the registrar to be in English, pleadings and submissions, as well as the substantive arbitration proceedings themselves, must be conducted in Arabic. That is not merely a procedural technicality. my learned friend would urge upon this tribunal. It goes to the heart of the parties' agreement, back to party autonomy, members of the tribunal. The request was not validly filed in accordance with the parties' arbitration agreement, and it must therefore be refiled with a consequent effect on the commencement date of this arbitration.
This is an issue that we will tackle at a later stage, Learned Counsel, the date of the beginning of and the deadlines, etc. Let us focus on the language part and finish from it, if you may.
The language part, let me put it this way. It's not what you do, it's the way that you do it. And quite frankly, my learned friend has done it wrong.
In response.
You may answer.
We agree with just about everything my friend Mr. BBC says, except his application of the rules. By agreeing through party autonomy to OIC rules, they've also agreed to the provision on waiver, and that is exactly what they have done in this arbitration by failing to object to our submission in English, by putting forward their own submissions in English, and bringing forward counsel that does not speak Arabic. I'd suggest that Mr. BBC's point is what is actually on another planet, that we're going to have two parallel languages in this
This is an issue to be decided by the tribunal. In this regard,
indulgence of my learned friend cannot constitute waiver. We are speaking in English out of pure indulgence to my learned friend. No waiver.
Very well noted. Thank you very much, both of you. We will deliberate for 5 minutes, and then we'll get back to you as a tribunal.
Okay, I'm going to freeze them and I'm going to turn to the audience before the tribunal may ask a couple of questions and give a deliberation. The issue here is the arbitration clause says proceedings shall be in Arabic. We've heard claimants' counsel, we've heard respondents' counsel. So the position is that under the OAC rules, you can deal with the registrar in Arabic or in English, but it doesn't say you can necessarily have the proceedings in English if the parties have chosen Arabic. You've heard arguments on both sides where they say one party saying it doesn't matter, the request was filed in English, they've waived any right to be in Arabic or otherwise. The other side saying, no, we need both parties' agreement. It's absolutely clear the proceedings should be in Arabic. And we'll wait to hear what the tribunal has to say on that. Can I have, from a show of hands, who thinks in a situation like this, where the arbitration clause says the language to be used shall be Arabic, should there be a discretion, or is there under the OAC rules for the tribunal to determine the language can be something else? Can I have a show of hands if you think it should be Arabic? It should be, I need to see your hands, okay. And those of you who think it should be English? And we've heard counsel say that proceedings were filed in English and therefore there's been a waiver. Who agrees there has been a waiver because proceedings were filed and accepted in English? Okay. Does somebody who said that it should be in Arabic want to explain to us why they've said it should be in Arabic? There should be a roving mic here somewhere. Anybody? Raise your hand. No? Okay. In that case, I'm going to turn back to the tribunal. They may have questions before they give their deliberation.
Regarding this specific point, the tribunal has deliberated and we have decided unanimously that the proceedings are to be conducted in Arabic. However, for practicalities, we will allow some instances in English language to be translated to Arabic according to OAC rules. Now we move on to issue number 2.
And if we have counsel, both give their views on issue 2, and then we have questions from the tribunal. Thank you.
So the issue number 2, or the issue to be determined number 2, will be whether the respondent materially have breached the agreement during the 2024 conference.
Late response counter claim. Read the question number 2.
هي question أنا الأوردر تبعه بنمشي فيه.
Procedure. Substance.
Okay.
If we can have counsel submissions on the second issue before the tribunal.
Yes. Mr. President, members of the tribunal, there's a further consequence of the respondents' late submission of their response.
Excuse me, Lord Counsel, we are still deciding to which point we are going to talk about. So now the issue will be related to your response on the counterclaim. So if you may proceed with this issue, would be grateful. Thank you.
Late response and counterclaim. Yes, this is precisely what I wish to address. So, as we know, in Article 5.1 of the OAC rules, a response must be filed within 21 days of the request for arbitration. Therefore, it was due on April 5th, 2025, calculated from the date of receipt, but it was only submitted on April 20th. Now, it's pure arithmetic here. The request filed on March 15th means the response was due on April 5th, but it was submitted only 15 days after that deadline. Articles 3.7 and 3.8 of the OAC rules are clear that the holidays and non-business days do not count within this date unless they are on the last day of the period. April 5th fell on a Saturday, a non-business day in Oman. Therefore, the response was due on April 6th. It was not submitted then. It was submitted only much later. Article 5.2 of the OAC rules states that failure to submit a response will not prevent the arbitration from commencing, but perhaps more importantly, it also says that failure to submit the response within the time period will constitute an irrevocable waiver of that party's right to nominate an arbitrator. In this case, the respondent had waived its right to nominate an arbitrator, and with all respect to our wing, Dr. Cleopatra Almars, her appointment was illegitimate. It was outside the deadline for beyond the point of waiver.
Excuse me, are you challenging her appointment or what? Just for us to be on the same pace.
We have no substantive objection to Dr. Almars as far as bias or anything of that
Either
nature.
you're challenging or
we'll
you're
be
not
happy
challenging.
to appoint her in another arbitration in the future from our side. But in this arbitration, the respondent has failed to submit the nomination in time, has waived irrevocably, cannot be restored within the time limit, and therefore the tribunal must be reconstituted under Article 11.2 of the OAC rules by the Executive Committee.
All right, this is what you are complaining about? My nomination?
Madam Almaz, we are not complaining about your candidacy. We are complaining about the late nomination. As I mentioned, we would be happy to appoint you in another arbitration from our side. But in this arbitration,
what are the grounds of your challenge?
The ground of challenge is they have irrevocably waived, irrevocably, this is not discretion, irrevocably waived by failure to submit their candidacy within the date for the response.
But I think there are formal ways to challenge an arbitrator, not like this.
Well, this is not it's not a challenge. It's not a challenge to the identity of the arbitrator. It's a defect in the appointment.
Excuse me. Either you're challenging or no, you're not challenging. We need to know your position. If you're not challenging, we move on. If you're challenging, tell us the basis.
We are challenging a fundamental defect and flaw in the nomination process, which can lead, in the event, at the end, to a failure of follow the party's procedure and a possibility of a challenge to enforcement eventually. The tribunal must be nominated in accordance with 11.2 of the OAC rules by the Executive Committee. When there's a default on the appointment process, it needs to be appointed separately by the Executive Committee.
Well, Counsel, if I may, well, delay do happen. And unlike arbitration deadlines, I have a plane to catch and duty-free perfume section waits for absolutely no one. So if we can move on this point.
Well, from our perspective, you are free to go and we can proceed with the nomination of your replacement.
It's not a nice way to address a member of the tribunal, Lord Counsel.
We have the utmost respect for Dr. Almars, but in this case, there has been a failure of the appointment process, and we submit that the Executive Committee needs to reconstitute the tribunal, not to anything to do with Dr. Almars, but with the respondent's default. Default on the response and its irrevocable waiver of its right to nominate.
He will speak for himself. Are you done with your statement? Or you have anything more to say in this regard specifically?
No, sir.
Thank you.
If I may, I am still a sitting arbitrator, and me leaving this session would mean the end of this hearing.
Yes.
So far, I'm staying, and the proceedings will continue on these bases.
Thank you. Loan Counsel, what's your position on the matter?
Members of the tribunal, I'm obliged. And first of all, I would say that my learned friend really should not be currying favor by offering future appointments to any arbitrator, let alone an arbitrator whom he himself is challenging. But let me respond to the substance of my learned friend's submission. We do acknowledge the timing issue. Now, it's right that Article 5.3 of the OAC rules, again, is clear, and it states, failure to deliver a response or any part of it within the time stated above shall not by itself preclude the respondent from advancing any defense or counterclaim in the arbitration. Now, it's very simple, members of the tribunal. The 2-week delay was not intentional and should not prejudice in any shape or form the substantive resolution of the issues between the parties. Our counterclaim, filed on the 20th of April 2025, contains all of the elements of a sound and validly constituted counterclaim under Article 5.6 of the rules, the nature and circumstances of our counterclaim, the relief sought, the quantification of Omani Real's 2.48 million being claimed, and the relevant agreements. Now, as for arbitrator appointment, the rules permit the executive committee to grant extensions of up to 14 days under Article 5.4.
Were these extensions granted? Was the extension granted?
That is somewhat unclear, but really we don't actually need to go down that route because
the rules were set for a reason.
Well, yes, but it's overtaken by events with respect, because here we are and the tribunal is impaneled. The tribunal has already been invited by my learned friend to determine one issue. He didn't take the invalidity of the appointment of the respondent's arbitrator at that point. He relied at that stage, you'll recall, members of the tribunal, on waiver. What greater, more clear evidence of waiver is there than the fact that he allows the first issue to be decided upon by the full arbitral panel and only chooses to take this point when the panel has already not only been impaneled and is sitting, but has already taken a substantive procedural decision. He's too late.
My colleague, Dr. Cleopatra, is highly respected in the industry, but I do not understand how you believe it's okay to be 2 whole weeks late from the submission deadline. What you have done is unacceptable, and I think the formalities has not been met.
And Mr. Arbitrator, we have apologized, we have accepted the lateness. The question really is one of procedural efficacy and the need for arbitrations to proceed speedily and efficaciously. I think that is common ground. And on the basis of where we are now, it is my clear submission that Madam Arbitrator has been validly appointed in the first instance, or if not validly appointed in the first instance, any omission has been overtaken by circumstance. And really, having reached the point of being overtaken by circumstance, we should move on efficaciously with the substantive hearing.
Allow me to interfere and add that the Learned Counsel, the claimant's representative, he challenged my colleague. However, you challenged me as a respondent. Would you be kind enough to explain the grounds of your challenge and what are you aiming for from it?
Dr. GCC, and Again, one knows not what the acronym.
Before we move on, I think.
You need to say something.
This is an issue. We'll have the tribunal determination and questions on this issue in a second, but just for your benefit, what's happened here? This is the second issue we're dealing with. You've heard from the claimant and you've heard from the respondent. The claimant's position is there's a 21-day deadline under Article 5.1 of the Oman Arbitration Centre's rules. And the response was due by the 5th of April 2025, and that's calculated from when the request for arbitration was sent out. However, the respondent didn't submit a response. They submitted a counterclaim, and that too was dated 20th of April. What the claimant relies on is saying that Article 5.2 of the OAC rules says that the failure by the respondent to submit a response Article 5.2 says, failure by the respondent to submit a response shall not prevent the arbitration proceeding from commencing. Article 5.2 says a failure to send the response within the prescribed time will constitute an irrevocable waiver of the party's right to nominate. So what counsel's saying is, because you didn't put your response in the prescribed time, your appointed arbitrator isn't appointed properly. So there's a kind of quasi-challenge, if you like. And what the claimant's position is that the respondent has waived its right to nominate an arbitrator and she should be removed. And under the Article 11.2 of the rules, a new arbitrator should be appointed by the exec committee. On the other hand, the respondent's position is, yes, we acknowledge timing is an issue, but failure to deliver a response is not by itself fatal. It doesn't preclude us from advancing a defense. And the 2-week delay was not intentional and should not prejudice our rights. They've put in a counterclaim and they're saying that everything in our counterclaim is compliant. All of the requirements under the rules, Article 5.6, are met. And as for her appointment, what they're saying is the rules allow the executive committee to grant an extension. And you don't need to go that far. You've already dealt with the application made now, and therefore you can deal with this position as well. Can I ask you, and you may have or not been in this position, when there's rules that say there's a specific time for things to be filed or lodged, firstly, what do we do if we want to increase that time, and do we have the right to? What would you do if you couldn't comply in that timeline? What's the first thing? Gentleman at the back.
It'd be normal to ask. It would be normal to ask for an extension of time.
You could ask for a joint extension between the parties and see if the tribunal agree. So they haven't asked for that extension, but they've gone ahead and filed. The tribunal is now left with the decision to make, are they going to accept that late filing in the absence of an application? And does that filing have any effect on the appointment of this arbitrator and the ability of the respondent? Given what you've heard, do you think without an application and putting something in late, does that affect the validity of the counterclaim, and does it affect the appointment of their arbitrator? Can I have a show of hands who thinks that it does affect the validity for the arbitration to proceed? And can we say why you think that? Does anybody want to volunteer? Lady here.
Oh, sorry. I would like to say that it would affect the validity of the proceedings, because unless there was a time extension granted by the EC, the appointment of the arbitrator is not valid.
Does anybody have an opposing view? And if so, could they share it? Gentleman at the front.
Of course, the respondent had a specific time to respond and to appoint its arbitrator in its response. But despite the fact that he was late in appointing his own arbitrator, the appointment was valid for a simple reason. What did the claimant do when the respondent was late in appointing its own arbitrator? The claimant did not go to the center or to the appointing authority saying that, look, the respondent did not appoint its arbitrator within this time limit, so please appoint an arbitrator on his behalf. While the claimant did not do so, so the claimant waived its right to object to the respondent claimant to the respondent right to appoint its own respondent right to appoint its own arbitrator. So that the appointment was in fact valid from my point of view for also other reasons. If I am in the tribunal, we will add many other reasons to validate the appointment of Ms. Claudia Haj.
Thank you, sir. So basically, the gentleman's position is that you failed to object on time, and therefore there's an acquiescence, there's an acceptance of that tribunal appointment. I'm going to be quiet now, and we're going to hear the deliberations from our tribunal members or any questions on point before they make a decision.
Okay. So,
you can deliberate so everyone can hear. That's the point, so they can hear you with your mics.
okay, the tribunal has deliberated and decided unanimously according to OAC rules to confirm the nomination of our esteemed co-arbitrator, Dr. Cleopatra Elmars. Welcome again to the tribunal.
But just, Sarah, if I may, outside the this matter does not belong to the tribunal to decide on. As per the rules, it is up to the center and the court to decide on the validity and the appointment of the tribunal. But because this is a mock arbitration, we're just bringing up these subjects.
Totally agreed. However, we did this and we approved unanimously so that we can continue the hearing, right? Thank you.
I think we're on to our third issue now.
Or the AC is here, you can appoint her now. Okay, so since this challenge was made by
Indeed.
you, can you please elaborate on the matter so that later on we can hear the response of your...
The application needs to be made by counsel. We understand there's a challenge to the presiding arbitrator, and counsel will set out the basis of that challenge.
Yes, it is regrettable, members of the tribunal, that I must pursue this application. We submitted a challenge to Mr. Dr. Presiding Arbitrator, Dr. GCC. Now, I have no doubt that modesty precludes him from identifying what the acronym GCC means or stands for. Of course, it stands for Most Gracious and Charming Chair, but notwithstanding that he is, of course, the most gracious and charming chair, we do challenge his appointment. We challenged his appointment 20 days after his appointment based on his connections with the claimant's counsel, Mr. Pluto. The connection, I'm afraid, only came to our attention 18 days after the appointment. Let me, members of the tribunal, just clarify the substantive basis of this challenge.
Can you please elaborate what kind of connection you're talking about?
There was indeed, I'm afraid to say, Dr. GCC, a very clear and rather disturbing connection. I have it on good and reliable authority, namely a fly on the wall in previous proceedings, that during an arbitration held in Dubai, in the course of Dubai Arbitration Week, between yourself, Mr. Dr. GCC, then an party-appointed arbitrator, and the same counsel, Mr. Pluto, that there was a distinct lack of independence. Indeed, the antithesis of independence. It was, to put it frankly, a concert party. And on that basis, we have no faith and confidence in your independence. Under Article 13.2 of the OAC rules, challenges are permitted within 14 days after the party becomes aware of such information. Now, I'm afraid it took some time for the fly on the wall to fly and reach me and my clients and for us to be aware of this matter. A party only waives its right to challenge if it fails to bring a challenge within 14 days of the date of discovery of the relevant circumstances. We submitted our challenge within the 14-day period, and we say that that should run from the discovery of the connection, the fly's arrival, and our knowledge through the fly's information, and not, of course, from the appointment date of your good self, Dr. GCC. The circumstances giving rise to the justifiable doubts only therefore became known to us after conducting due diligence. We thoroughly interrogated the fly, and the fly was clear that there was a clear conflict between your good self and Mr. Pluto.
If I may, 18 days. In 18 days, I can discover 2 conflicts and 2 scandals and maybe a new mascara. It took you 18 days to challenge the president of this tribunal?
Madam Arbitrator, I fully accept that your good self experienced 3 conflicts, 2 scandals, and 1 incident involving mascara in the course of 18 days.
Mascara.
But look, only the mascara separates you from President Trump, and therefore the mascara makes it simply a cosmetic exercise.
I don't see the relevance of this regarding our case anyway. I believe the claimant has something to say.
Yes, Mr. President, this challenge is clearly time barred, we would say, first of all.
Counsel, speaking please of time bar, like the coffee break, if we don't move this, but please do go on.
Yes, thank
She
you.
needs her caffeine.
Dr. Lamars. The Article 32 requires submission of a challenge within 14 days from the date the party becomes aware that circumstances exist. Now, the respondent was notified of the tribunal's constitution, and 6 days, the challenge was only about 20 days later. 6 days was more than sufficient time to investigate any potential conflicts. The mock arbitration in Dubai was well publicized, well known. As the respondent acknowledges, due diligence is appropriate in the circumstance. It could have easily discovered this, and Mr. BBC was in fact present at that hearing. More importantly, Article 13.2 of the OAC rules only permits a challenge where there are circumstances that exist that give rise to justifiable doubts as to the arbitrator's impartiality or independence. And we submit that joint participation in a mock arbitration gives no justifiable reason to doubt bias. We are all here participating in a professional event, just as happening in Dubai a couple of weeks ago. There is no basis to consider that the joint participation in these events give rise to any sort of bias. It's a completely unrelated dispute. It is a completely fictitious exercise, and we submit that this challenge is not made in good faith, and it is simply to besmirch the reputation of most gracious chair.
Couldn't you just have disclosed it and just spared us all this wasted time on this matter and the application to challenge the president?
Absolutely, Dr. Mars. We think it would be the best use of the tribunal's time if the respondent would withdraw its application.
This statement is taken off the record, of course. Anyways.
Okay, before I ask them to, well, I ask them to be quiet. This is the 3rd issue here. It's a challenge to the presiding arbitrator. The basis of the challenge is we ran a tribunal in Dubai in November, and we had this individual as counsel, and the party-nominated arbitrator at that stage was Dr. GCC, and I think the claimant's counsel was, as her response counsel was a mere observer, and said that there was a lot of interaction between the two. There's clearly a conflict because there's a partisan view taken, he's not independent, and that's the basis of the challenge. And the issue that's been raised is, well, hang on, you can't challenge now. They submitted a challenge 20 days after the appointment based on the connections. They say they only came to our knowledge 18 days after his appointment. The OAC rules say under Article 13.2, challenges can take place within 14 days after the party becomes aware of any information. And a party only waives its right of challenge if it fails to bring up a challenge within 14 days of the date of discovery. Their position, the respondent's position, is that 14 days runs from when they discovered the connections, and they discovered them through this fly on the wall, who their counsel spoke to the fly. He speaks fly language. Therefore he couldn't have bought it earlier. For the claimant, they say, hang on, Article 13.2 requires that submission within 14 days, when the party becomes aware of circumstances that give rise to justifiable doubt. And they emphasize the justifiable doubt. They're saying there is no justifiable doubt about the impartiality just because he's been on a tribunal before and he was the party-appointed arbitrator. And they say that Article 13.2 permits a challenge only where there's circumstances that, you know, either the impartiality, independence, or doesn't possess the requisite qualification, and some vague allegations that are made about this arbitrator being connected to this council are not substantiated. There's not enough information. Can I have, from a show of hands, before we have deliberation or decision, who thinks that there's a proper challenge to the arbitrator and it's been brought in a timely fashion? So number one, the fact that this arbitrator has acted for this party as a party-nominated arbitrator before and shown, according to the other side, some kind of relationship. Is that enough to raise a challenge? Can I have a show of hands if you think that's enough? So nobody's really convinced. We have one or two people who've raised hands. So do the majority of you think that's not enough to raise a challenge, that kind of connection? And if so, can I have anyone explain why? Any of the people who've said that it's not enough? Or maybe you can explain why you say there is a challenge. Yeah, thanks. I want you guys to get involved. It's for you. It's interactive. Tell me your positions, what you're thinking before the tribunal tell us.
Okay, thank you. I think the chairman should recuse himself because the objection was made on time before the proceedings commenced. And secondly, because the chair has took part in previous proceedings involving the claimant's counsel.
So you think he should recluse himself? You think it was made on time at the time it comes to their knowledge and therefore it's valid? Anyone want to take an opposing view and give me their decision, please? Is somebody here? Sorry?
He's just next to me.
Okay, I like that. Next to you.
My point comes from 14.1,
Mhm.
the last sentence, or should have reasonably been known to that party. Now, it comes to a question of, is the information, regardless of the time being put, could have been reasonably known at the beginning of the constitution of the arbitral tribunal, or at a point in time that kind of allows for the time to pass. So the fact that the respondent knew about it at a certain point in time is to an extent irrelevant if they ought to have known about it before. So it depends on how this information was essentially.
Well, we've heard them say they found out from a fly on the wall. You've also heard me say that their counsel was actually at those proceedings as an observer. So I'm going to stop there. Thank you for your opposing views. And I'm going to turn to the tribunal.
If I may, Sarah, the main issue here is whether it is time barred, regardless of the incident itself, because if it was within the 18 days, the president could have been removed. What we are looking at is because they discovered it after the time period that is prescribed in the rules, whether at this point in time they can still challenge the president of the tribunal.
And over to the tribunal for any comments.
I think we'll keep the pace and we'll move on with the issue of interim measures. I think the claimant have submitted a request to the respondent to provide a bank guarantee for Omani Riyal, 1 million Omani Riyal, corresponding to unpaid fees. What would you say about this?
Thank you, Mr. President. Yes, we are seeking a bank guarantee of 1 million Omani Reals as security for our damages claim. And the legal basis for this is Article 24.1 of the Omani Arbitration Law, which provides that the parties may have an agreement to the effect that the arbitration board may issue orders to take suitable temporary or precautionary measures necessitated by the nature of the dispute. In this case, we do have such an agreement by the agreement to arbitrate under the OAC rules, Article 25 of which empowers the tribunal to grant interim measures of protection that are not barred by mandatory law. There is no provision of the law which suggests that a bank guarantee is not available in these circumstances. Accordingly, we have an agreement to arbitrate that allows these types of precautionary measures. Moreover, under Article 24.2 of the Omani Arbitration Law, this will be enforceable by a court, so it does not require the follow-up or supervision of the tribunal. Now, we say this measure of a bank guarantee is necessary for the following reasons. One, the respondent is continuing to deny any liability despite clear evidence of breach of the agreement. Two, the respondent has made no attempts to remediate the breach. Three, the respondent is a privately owned LLC and a mere service provider with no known or substantial fixed assets, and there is a risk that if the measure is not taken, there will be nothing for us to enforce against. Four, there is a risk of asset dissipation because the respondent has been intransigent in trying to, in any request to provide a security. And finally, we say the measure is proportionate. Our claim is 3.5 million Omani Reals, whereas the security is only 1 million Omani Reals. And we would also point out that this is not a burdensome measure we're requesting. We are not asking for an interim payment. We're not asking for a deposit in the bank. We're not asking for a freezing of its assets. We're only asking for a bank guarantee, which, if the respondent is solvent, a thriving business, there should be no difficulty for providing it, as the bank should show they are good for the amount. They will not be out of funds. This will only be called upon in the event they lose the arbitration. For those reasons, we submit that our request is both well-founded and proportionate.
Thank you. Before giving the floor to the Respondents' Council, my colleague has to say something.
Well, 1 million definitely is a number worthy of delaying the coffee break. My follow-up question is, I'm trying very hard to find where both parties' agreement can be identified. Can Council explain to us where we can find this mutual agreement?
The mutual agreement is that the tribunal has the power to issue interim measures of this nature. And that agreement is found in the Omani commercial arbitration rules. And that is at, as I mentioned earlier, at Article 25.1, the tribunal has the power to grant interim measures of protection that are not barred by any mandatory law. The Omani arbitration law expressly permits measures of protection, and there is no prohibition on security in the form of a bank guarantee, which we submit is entirely appropriate and proportionate to circumstances.
Thank you, Council. My colleague has to say something. Dr. Farsi?
You are already withholding 2 million riyals of unpaid fees. So why do you need this additional guarantee?
The guarantee is to, it's not even, our claim is 3.5 million Omani Reals. Yes, we have held this 2 million. The 1 million will cover not even the full difference. This is what is necessary to secure our claim against the risk of non-enforcement.
Noted. Thank you.
Yeah.
Lord Council.
Thank you, Dr. Chair. My learned friend has correctly stated the law and taken the tribunal to the correct provisions in the rules. But simply stating the law and the rules is not sufficient if the application is totally wrong. And here his application is totally wrong. We strongly oppose this request. The claimant has not demonstrated any of the prerequisites for interim relief under either the law and/or the rules. My learned friend relies, first of all, on the respondent continuing to deny any liability. Yes, my clients do. They have no liability that will be determined at the substantive hearing. There is no basis for entering into any sort of mini trial here. We stand on our refutation of liability. My learned friend says we've made no attempt at remediation. Again, he's correct. Why should we? We are not liable. My learned friend says there is a risk of asset dissipation. That is wholly wrong, and I'll come back to it. He says the measure is proportionate. That again is wholly wrong. My learned friend relies on Article 24 of the Oman arbitration law. And what he cited, insofar as he cited it, was correct. But he did not read the whole provision, of which the tribunal will be only too familiar. Article 24, in fact, continues, and the board may discretionary, may order submission of an adequate security guarantee for covering the expenses relating to the measures to be taken as per its directive. Now, there is no evidence of asset dissipation. We are an established media company. The dispute concerns service quality, not my client's financial capacity. The amount claimed by my learned friend is entirely arbitrary and is punitive in its effect. Just remember, members of the tribunal, the claimant has already unilaterally and without any legal basis whatsoever withheld 2 million Omani riyals from my client. They now have the audacity to come before this tribunal and seek additional security, which is wholly unnecessary. And that is sufficient to establish beyond doubt the lack of proportionality in this claim. We say that only Omani courts should order such pre-award security measures in the absence of compelling evidence of imminent harm. There should be no award of any interim measures on the facts of this case whatsoever.
Thank you, thank you. I believe now we need to move with Sarah to the last issue.
Okay, I don't know how many of you followed what's gone on there, but in a nutshell, this is a request for interim measures from the tribunal. And the position of the claimant is, well, hang on, the respondent owes us money. The respondent owes us like 3.5 million or 2.5 million. We're asking for 1 million as a security from you, an interim measure, obviously a temporary measure. And they've referred both to the Omani arbitration law and the OAC rules. The Omani arbitration law says both parties to an arbitration may have an agreement to the effect that to the arbitration board they can issue orders. And it goes on to say, as counsel has said, that the board may order submission of an adequate security guarantee for covering the expenses related to the measures to be taken. And it says that also requires a requesting party to provide a counter guarantee, not just demand a guarantee from the other side. The position of one is we need this 1 million Omani Rial security because the respondent is denying liability. They've made no attempts to try and sort this out. There's a risk that they're going to dissipate assets and the measure's proportionate. The other side's position is actually there's no risk of asset dissipation. We're a long-established media house. Where are we going? The dispute you have with us is not about financial capacity of ours, it's about service, and the amount is arbitrary. So they're saying that the claimant's already not paid us, and now they're asking for more money as an interim measure from the tribunal. Can I have a show of hands of who thinks the tribunal are going to grant an interim measure to the claimant in these circumstances for 1 million for damages they say they've suffered because of the respondent's alleged breach of the agreement in being able to properly broadcast this space conference? And please get involved. Just give me a show of hands. Who's on the side of the claimant here? One. So one, Abdullah, thank you. So are we all for the respondent here? We all think a hand show, please. What respondent? Okay. Why? Can I have somebody to explain to me why? Anybody? Dr. Abdullah, maybe you can tell us why you're on the claimant side. On you, okay. Somebody, the microphone over here. Can we have the microphone, please, over there? The lady behind her, Dr. Abdullah. And I want somebody to tell me from the respondent side why you're on their side. You can't just say you're on their side and then not give me a reason. That's not how it works in real life. Come on, we're all lawyers.
Actually, I'm not an arbitrator, so I'm gonna leave it to the tribunal discretion. Actually,
You're sitting on the fence. You're not actually for the claimant. Somebody who's actually on the side of the respondent, please give me their view. There's a gentleman at the back over there. Can you raise your hand again? So why do you think the tribunal are not going to give this request for interim?
In terms of an interim measure such as that, it's a balancing exercise. And one of the considerations is, will it extinguish a legitimate claim or counterclaim? And it seems in this case, from what I've heard, that it's a tactical application as opposed to a genuine application. So I'd be more inclined towards the respondent based on what I've heard.
Sorry, I'm not sure I caught all of that. It's because of what?
It's an exercise of discretion. The tribunal don't have to grant it. They've got to balance between the claimant and respondent. Based on what I've heard, I'd lean more towards the respondent, that it appears that it's an attempt to stifle their counterclaim.
Okay. So we're talking about the status quo here and saying that the balancing act is taken into account by the tribunal, and here the intention is just to stifle a claim. It's not properly needed to ring fence. Anybody else want to give a view before we turn back to the tribunal? There's a lady here. Thank you.
We just wanted to add, we've been teaching our students advocacy skills this week, and I think we were more convinced by the respondent counsel's arguments there. And poise, yes, we've been talking about poise and voice in our classes this week.
That's no slight on our other counsel at all, I may add. Everybody has their own styles and they're both superb. Okay, so you've been persuasive, but let's see what our learned tribunal has to say.
Unanimously denied.
So actually, despite a decision I think that everybody envisaged, we're going to move to our last issue now, back to the tribunal to open that.
Okay, so our last issue for today's hearing relates to the evidence and admissibility of the digital materials that were presented in the case. The claimant submits social media metrics, live stream recordings, and audience engagement reports. Respondent argues these are not notarized or formally authenticated under Omani evidence law. Claimant, what's your position on the matter, please?
Thank you, Mr. President. In respect of the evidence has been advanced by the claimant, the tribunal has broad discretion to determine questions of admissibility. Neither the Omani commercial arbitration rules nor the Omani arbitration law contain any special rules on admissibility of evidence, nor do they require strict compliance with the Sultanate decree on the law of evidence in civil and commercial transactions. The decree itself only applies to court proceedings in Oman and only expressly deals with documents and witness testimony. Its certification rules do not apply to audio and video recordings, only to official documents. And even under the decree, where it's a question of authenticity of evidence is raised, it is sufficient to call the person who made the recording or to report to testify as to its authenticity. And we are prepared to produce such witnesses if necessary. However, we submit it's not necessary because we submit the appropriate standard to be applied is that which is common in international commercial arbitration, the IBA rules on the taking of evidence on international arbitration, and the tribunal should be guided by its provisions. And Article 9.1 of those rules clearly state that the tribunal has full discretion to determine the admissibility, relevance, materiality, and weight of evidence. If we apply those standards, our digital evidence is clearly admissible. First, it's directly relevant. It shows the exact times and duration of the service interruptions at the conference. 2, it's reliable because it has embedded metadata and timestamps. 3, it's verifiable because it can be technically authenticated by the people who made the recordings. And 4, it's necessary because this is really the only evidence that we can use to prove that the digital service failures. So on that basis, we submit that the evidence should be admitted, and we will hear the respondents as to why they suggest it should not be.
Thank you, Learned Counsel. Respondent, please.
Thank you, Mr. Dr. Chair. The position is very simple and straightforward. Digital evidence needs to be properly authenticated. This has not been, and it is therefore inadmissible. Let me elaborate on that solution to this application. Under Omani law, electronic evidence requires certification and verification to ensure authenticity. And that is for very good reason. But let us begin by looking at the evidence that my learned friend, Mr. Pluto, on behalf of his client, has put forward. I think you have that in the bundle, sir. And let me hold it up. The first is a picture of something rather like this auditorium, which shows a whole load of people in the audience listening to people on the stage. What does that prove?
That's Exhibit A in the bundles in front of you if you want to follow it.
That, members of the tribunal, I might say, is the high point of my learned friend's evidence. He puts forward, in support of his case, Exhibit B. Exhibit B is nothing more than a progressively diminishing set of blobs. I have no idea, members of the tribunal, what this is supposed to show, let alone prove.
Maybe after you finish, he can explain this issue. After you finish.
I wait with bated breath for the explanation. But the materials that my learned friend has put forward are unverified and can easily, we know, my clients know this as a media company, can easily be manipulated. Social media metrics without proper verification and API authentication are completely unreliable. Audience reports have apparently been provided, but without any identified sources, and recordings have been put forward, but without any chain of documentation verifying the custody of those recordings.
Counsel, if I may. First of all, a remark on the side. If in these days filters are counted as manipulation, then my Instagram would be inadmissible in 47 jurisdictions. Now, back to the case. May I take the parties to clause 4.2 of the agreement and ask the parties what is their respective position in relation to what 4.2 of the agreement says? And I can read it out loud.
Yes, Madam Arbitrator, I have paragraph or Article 4.2 in front of me, and it reads, any failure to meet performance standards, including interruptions of broadcast or errors in social media reporting, will constitute a material breach of this agreement.
Absolutely. And if you read this in correlation with 12.1, 12.2, sorry.
Indeed, Madam Arbitrator. And I think in performing the exercise that you have performed and invite everyone to perform, you have, in my respectful submission, answered your own question, because the whole agreement must be read as a whole. Looking back at 4.2, the interruptions of broadcast were not interruptions which can be laid at the door of my client. They were for external and extenuating circumstances covered by the force majeure clause. So 4.2 is of no present application, whereas Article 12 is plainly of present application. And reading the two together, you can only sensibly give meaning to Article 4.2 if you read it down in a somewhat restrictive way, as I've indicated, and the tribunal can have confidence that that is the correct approach by referring, as the tribunal already has in mind, to Article 12 of the agreement. And I'm very grateful for that point being raised by the tribunal.
Actually, I was referring more to the notices that were supposed to be sent under both articles, and whether this is on record or
Were they
not.
sent, properly sent?
Well, the respondent says they gave prompt notice, but there is no actual evidence in the record. And if I might also address Madam's question, absolutely correct to point out that any failure is a material breach. Now, the respondent may have a defense of force majeure that is subject to its duty to mitigate the effects of the force majeure event. What's absolutely remarkable about my learned friend's position is that the only actual evidence that could determine this, it opposes the admission of this evidence. This is the real evidence. It is the respondent's burden of proof. The respondent's burden of proof to show this occurred by a force majeure event. Otherwise, it's strict liability under 4.2. They must establish the force majeure. The only way this can be established is by the recordings, by the reports, the very admission of which they oppose, which we submit is very telling as to the respondent's case as a whole. But more importantly, the objections that it raises to screenshots, this is not the full evidence, this is just demonstratives for the purposes of the request. The actual evidence is the only evidence that's capable of proving this, and it can be authenticated by the people that recorded it. But my learned friend doesn't want to wish to take questions as to weight. He doesn't want to cross-examine them. He wants to exclude it as a whole. And the question is why does he want to do that? If this evidence, if it is so confident in this case, why is he seeking to refuse to admit the very evidence that could prove his case if he is right in his defense?
The tribunal on both sides cannot find any notices related to the respective breaches raised by each party. So we will not dwell on this because I don't want to be late for the coffee break. However, we do bring your attention that neither party has proven to follow the procedure in the contract before we reach the question of the admissibility of evidence, which in either case the tribunal would look at. So we thank the councils for now.
Thank you. Do you need to say anything in response to him?
I was simply going to say that in response to Madam Arbitrator's point, my learned friend is quite inappropriately seeking to lure the tribunal at an interim interlocutory stage into what can only be described as a mini trial. At this stage, in my submission, one needs to focus on what the agreement says, construe the agreement as a whole, and read Article 4.2 down by reason of what is said in the force majeure clause in Article 12.
Thank you, thank you. Dr. Farsi, colleague, you have something to say? Maybe you have a question for the respondent?
I felt when you were discussing the evidence, you were conflating the merits of the actual digital files versus the admissibility. And do you believe that the tribunal has any limits on whether it can determine that as evidence or not?
Well, in my submission, questions of evidence need to be determined at the full substantive hearing. And therefore, what the tribunal must focus on for present purposes is a proper construction of the agreement. And I've made my submissions and rest my case on that correct basis for the tribunal to make the decision on this application.
Thank you. Thank you. Sarah?
Okay, so this is our final issue. It's to do with the admissibility of evidence. We live in an age where there's lots of deep fake. Social media is increasingly being used, and it's increasingly being used for evidential purposes. Claimant's position is, we've given you live stream recordings, we've given you social media metrics as evidence of the respondent's breaches, and they're also saying you as a tribunal have a broad discretion regarding the admissibility of this evidence. The tribunal have said, well, none of you seem to have followed the right procedures as per your contract, which means you have to give notices about any kind of breach and notice if there is a force majeure. But leaving that to aside, the claimant's position is that the rules, the actual OAC rules, don't require any strict compliance with the evidence law of Oman, which requires things to be authenticated and notarized. And therefore, the tribunal are left with the discretion to decide, is this evidence actually admissible? And they say the evidence should be admissible because it's relevant, it's reliable, it's verifiable. And the lack of notarization shouldn't make it non-admissible. It might affect how weighty you can see that evidence, but it doesn't mean it's not admissible. The other side's argument is, well, actually, there's very good reasons why this evidence should be notarized under Omani evidence law, because such materials can very easily be manipulated in this day and age. And actually, that's a real life issue, and it's becoming more and more in a tech age of deep fakes and what's actually reliable, what's proper, what's not, and should things be authenticated. And the other side's position is, without that authentication, without that notarization, then the minimum reliability for admission as evidence isn't even met. And the tribunal shouldn't accept this evidence in. So the issues here are, can the tribunal admit this digital evidence despite it not being notarized? And how much discretion do the rules of the OAC give to arbitrators to admit this evidence? So again, can I have from a show of hands who thinks this evidence should be admitted even though it's not notarized? We have 2 people who say it should, or 3. And the rest of you, I assume, say it shouldn't be admitted without notarization. Is that correct? Show of hands for it shouldn't be admitted. Okay, does somebody want to tell me why it shouldn't be admitted? Their own views, please. In the lack of notarization, anybody want to volunteer? No? Anybody want to tell me why it should be admitted? Again, gentleman at the back.
In terms of admissibility, it's down to the tribunal whether they can admit or not in this particular matter. My view is that it's quite probative, so it's of relevance. They may stifle the claimant's claim by not admitting the evidence. A lot of the arguments put forward by a respondent, they can make submissions on if the evidence is admitted to attack their credibility and reliability. So there's a danger they stifle the claim by not allowing that evidence in, which is unfair to the claimant. The respondents are perfect counsel to be able to deal with this in challenging its reliability, etc. So I think it should be admitted.
So you say it should be admitted even in the lack of authentication or notification. Most of you have decided that it shouldn't be admitted, but nobody's going to tell me why. Can somebody be brave enough to give a guess or otherwise of why, or tell me why, explain to me why it should not be admitted? Is it because you think it's not reliable? It doesn't hold enough weight? I'm having some nodding heads, but nobody coming to the microphone. Anybody? No? Okay, I'm going to turn back to our tribunal.
We will explain why. The tribunal may admit digital evidence such as the social media matrix and recordings, even if they are not notarized, because under the OAC rules, the tribunal has broad discretion to determine on the evidence, the admissibility, relevance, and materiality, and weight of such evidence. and it is not bound by the strict requirements of the Omani evidence law and the procedural rule. So, while notarization may affect the weight and credibility of the given evidence, it is not a prerequisite for admissibility in the OAC arbitration nor under Omani law. So this is why the decision eventually is yes, it is accepted.
And thank you, colleague. And I need to add up that this decision was taken by majority of the tribunal. Okay, our esteemed colleague, Dr. Farsi, is dissenting. However, his dissent, he will decide whether to say it orally or later on submitted in writing and to be added to the final award. Dr. Farsi, what's your position on the matter? Would you like to dissent now or later on? Later on.
Later on.
Thank you.
Before we wrap up, and I invite you to join me in thanking our stellar panel, I want each one of you, within a few seconds, just to give your takeaways to our audience of when you're sitting either as counsel or an arbitrator, what are the most important points from your perspective? Starting with you, maybe Michael, and working away. No, we're out. Proceedings are closed.
Okay, I'll begin by repeating what Professor Liu always said arbitration counsel should do. And that is, first, read the rules. Second, read the rules. The third thing you should do, I think you're beginning to get the message, read the rules. And then when you've read the rules, do the same thing with the law. In the course of the hearing, listen attentively to what your opponent is saying and be slightly flexible in relation to how you respond to the opposing counsel's submissions.
Thank you, Michael. Now, can we have opposing counsel takeaways, please?
I won't repeat many of their advices, which are also very important. I would also say it's very important to know your audience, know your tribunal, and to be able to read the tribunal. Because it's the only, absent some serious procedural flaw, it's the only court you're going to get. There's very rare instances of appeal from the tribunal, not at points of law, and you can be right and feel that you're right on the law or right on the procedure and be going home with the loss in the tribunal. So it's important to know your tribunal and to tailor your submissions to the tribunal while maintaining, of course, the integrity of your client's case, but know your tribunal.
Thank you. And over to the tribunal for your takeaways as you sit as arbitrators.
Yes. I would encourage, since most of the statements made by the parties were irrelevant, I would suggest and I would recommend, I would recommend that parties are encouraged to be concise, straight to the point, and focus on the relief sought in their request so that they won't waste any valuable time, whether the time of the tribunal or their own time. So focus is indeed a must in such matters.
Thank you. Claudia?
I will speak in Arabic, okay?
Fine.
بعد يومين مليئين بالنقاشات الكثير كانت مهمة وعميقة، يلي بحب أقوله اليوم إنه التحكيم ما يعني منه مرتبط مباشرة بالإجراءات التقاضي أمام المحاكم، عنده إجراءات خاصة تخضع للقواعد يلي تم اختيارها في حال كان التحكيم مؤسسة مش تحكيم حر. وبالتالي بتكون عندما يعني حدا عم بيكون ضمن إطار التحكيم بده اللي تفضلوا فيه يقرأ كتير منيح القواعد المركز، بده يقرأ القانون اللي بيتعلق بالتحكيم، بده كتير يكون في انتباه على أي قواعد لا تحترم النظام العام للبلد يلي يتم فيه التحكيم، لأنه هيدا بيؤدي للبطلان لاحقاً. وبالنسبة للمحامين بده يكون دفاعهم كتير مركز على النقاط ومسند على القانون يلي تم اختياره لتطبيق التحكيم وفقا له ولا العقد يلي توقع. علما انه بالقانون المدني معظم المبادئ في لها نص. يعني بيبقى القانون مؤلف من 500 700 900 ماده، معظم خلافا للكومن لو بالقانون المدني عندكم المواد موجوده يلي بتساعدكم تقدموا الدفاع. ودائما اكيد الشق الثاني واللي تفضل فيه دكتور طلال هو المطالب بدها تكون واضحه وبدها تكون محدده لتهين للمحكمين يقوموا بمهامهم، لانه المحكمين ما فيهم يطلعوا عن المأموريه المكلفين فيها. يعني اللي بيحددوا لها اياها الاطراف هن ملزمين بس يبتوا بالنقاط اللي تحددت لهم. وشكرا.
Thank you. I agree with everything she said. I didn't understand a single word, but I endorsed everything she said. Dr. Riyad.
I would like to thank Sarah Malik for hosting this session here. We've had so many arbitration conferences, but we never had such a moot exercise. So this has been a great experience, and I'm sure the audience enjoyed it. Thanks to all the members of the panel. Thank you very much.
Thank you. I'd like you all to join me in thanking our stellar panel, please.
Thank you all for your patience and for attending. Have a nice evening.
And I think we're done, and I think the organisers come forward again.